This is the American Law Journal.
As sexual misconduct scandals rock the nation, what are employers, employees, and the law going to do about it? I'm Christopher Naughton. This week on ALJ, when sexual harassment occurs at the workplace, people are told, go to human resources. Question is HR the solution or is it the problem? Here's Gina Passarella.
Is there any opportunity, is there any chance for Harvey Weinstein to come back?
No. This is a sea change. I think his last name will become a noun and a verb.
It's undeniable. High-profile sexual misconduct has sparked a movement, one that's been right below the surface all along.
First of all, I believe that the Me Too movement is a watershed event in the way people discuss gender-related issues, the way people discuss sexual harassment, the way people discuss gender-related disrespect.
The Me Too movement has absolutely had a positive effect on reporting sexual harassment in the workplace. The whole idea of sexual harassment has been elevated in the country's national consciousness in a way that we just haven't seen before.
But long before the Me Too movement, before Anita Hill, was Michelle Vinson, a bank teller trainee, later an assistant branch manager. Vinson sued Meriter Bank in 1978, charging that over a period of years, a bank vice president demanded sexual favors in order for her to keep her job. She testified that he fondled her in public, exposed himself to her, and forcibly raped her multiple times. Vinson lost at trial, the court finding the relationship consensual, but she won on appeal. Eventually, the case would be the first of its kind to reach the Supreme Court.
The court will hear arguments first this morning in Meritor Savings Bank against Vinson.
Sandra Day O'Connor, the court's first female justice, peppered away at the bank's lawyer.
Mr. Troll, do you concede that the trial court simply didn't handle a case as one involving a recognition of a sexual harassment or hostile environment type claim?
We would concede, Your Honor, that theory of law had not been applied to sexual harassment cases.
Okay, so you agree the district court really didn't try the case with that theory in mind?
He did not. However, I would hasten...
Now, do you agree that that is a valid claim under Title VII?
Title VII of the Civil Rights Act prohibits employers from discriminating based on sex, race, color, national origin, or religion. From the court's archives, handwritten notes reveal the justices struggled over the employer's liability, since Vinson never reported the harassment to the bank or police. Ultimately, though, the court found unanimously that Title VII covers victims of sexual harassment too, whether the perpetrator asked for sex as a condition of employment or created a hostile working environment. But how far we have come in the 30-plus years since Vinson is debatable. There's enough blame to go around. From Congress, who just changed its sexual harassment policy that for years made the process more difficult for victims than accused lawmakers, to law firms that allegedly protect sexual harassers. David Boies of Bush v. Gore fame has been chastised for helping his client, Harvey Weinstein, silence his accusers. And the biggest culprit? Maybe the very department designed to protect employees.
Reporting sexual harassment to HR can be crucial to having a viable lawsuit. The problem is that there are too many HR departments that exist at some level to protect the company rather than the employees.
But I think the fear is that the employee, may be retaliated against in some way. I think there's also a fear among employees that, why bother coming forward? If I come forward, nothing's going to happen, nothing's going to change.
Where we go from here is anybody's guess. We're already seeing same-sex harassment and women sexually harassing men. But at least one Supreme Court justice has made her views on the subject perfectly clear.
My hope is it is as effective for the woman who works as a maid in a hotel as it is for Hollywood stars.
For the American Law Journal, I'm Gina Passarella.
4 guests with me this week, and a fifth will be joining us from Washington, D.C. in just a few minutes. But first, right here on the set, Anthony Haller chairs Blank Rome's Labor and Employment Group. Chambers USA calls him a calm amidst the litigation storm. Mary Tiernan steps up to the plate once again. She's with the EEOC, the Equal Employment Opportunity Commission. Alice Ballard has gone head-to-head with employment attorneys now for decades. She represents employees in wrongful termination, discrimination, and sexual harassment lawsuits. And Joey Price with Jumpstart HR, a human resources consulting firm with offices in Greater D.C. and New York City. And joining us from Washington, D.C. is Ally Coll Steele. Ally is a former associate with Boies Schiller. That was the law firm that represented Harvey Weinstein. She's a former congressional intern, and she's now launched the Purple Campaign, and its mission is to end systemic sexual harassment in the workplace. What went on that brought your law firm under fire, and Dave Boies in particular?
Well, I can't speak personally to the Weinstein matter at the firm. I don't have any, I didn't work on that matter or know anything more than what's been publicly reported in the news. But I think the news sparked, as you mentioned, a conversation about the role of lawyers in this movement, and that was something that we took on at the firm.
Right, and the fact of the matter is you folks were reacting against something. I mean, it sounded like there was a groundswell at the firm that lawyers there wanted to take action. Something had happened with our profession that didn't sit well with your associates. Is that accurate?
The conversation about what the role of lawyers is in situations like this was very much what was sparked at the firm, and I think there's a question. We represent, obviously, people who are accused of reprehensible conduct all the time, and when you engage in those representations, what is your obligation to make sure that you're doing it in the right way, and what is the right way? And I think that's very much the conversation that it has sparked in the legal community because of what had happened at Boies Schiller.
From what I understand, Anthony, David Boies, or the firm, never suffered any ethical investigations. But let's face it, what happened not only with Weinstein, but with the Boies Schiller law firm got this whole ball rolling.
Well, yes, and I wouldn't make any assumptions because the Attorney General of New York filed a complaint against the Weinstein law firm, Harvey Weinstein's brother, and the board.
Not their law firm, but their company.
But the company.
Right.
But if you read that complaint, you will see that there's far-reaching allegations about the failure within the company. And it's not a big leap of faith to think that those allegations may, at some point, go to the next stage to the law firm that was representing him. But I think the lesson for us, sort of in a more general sense, is that this has created a completely new environment, and we need all of us, lawyers, human resources personnel, and employees, to look at these type of situations in a completely different light and rethink what we've been doing.
The story about the law firm has helped me explain better to my clients about what happens when you make a complaint. It's not just that you go to HR. You go to HR and they do an investigation. And the investigation is done by a law firm, a supposedly independent outside law firm. All right, so this gives people sort of the worst case scenario about what a law firm might do in such an investigation. And if you go the next step into litigation, I tell you, you will be crucified. The case is, you're the one who's on trial. You want to put your boss on trial. That's not what happens. There are some really fancy lawyers who are being paid a lot of money to make you look bad.
And to protect a client, because let's face it, as attorneys, we enjoy a privilege with our clients. It is confidential. We are there to represent our clients zealously. So again, I'm not here to indict David Boies, but I'm asking questions about what the lawyer's role is when they are perhaps protecting a client who is maybe a serial sexual harasser. What role do we play? Now, we could ask the question in any criminal court of law, what role do we as lawyers play? But those questions have to be asked.
Well, Christopher, I think that this raises a very important issue, and I think many lawyers just don't really appreciate the role they are playing in these type of situations. You have to decide, first of all, are you representing the client, or are you in fact the investigator? Because if you're the investigator, you need to be independent. So as the traditional firm that represents a company, it's probably not a good idea in a situation like Harvey Weinstein's for you to be doing the investigation. And by the way, that's part of the complaint that the Attorney General is making, that the board did not bring in somebody independent, that there were too many conflicts of interest, and that they actually didn't hear about the problems and didn't react quickly enough.
Well, something has sparked beyond the legal community. It's actually sparked in the halls of Congress, and maybe you can share a story or two, Ally, and that is that the House of Representatives is now prohibiting sexual relationships between lawmakers and their staff. Share to the degree you're comfortable, you witnessed harassment and experienced it yourself in the halls of Congress.
When I told my story in October when the Me Too movement was taking off, one of the positive things about it was that members of Congress started sharing their own experiences with this as well, and this bill that you're mentioning was introduced as a result of that. And it makes a lot of important changes to the way Congress handles internally their own complaints, which as a workplace, they had their own rules that were different from most places and that made it very difficult for people who've experienced harassment to come forward and to obtain relief when they do.
Tell us a little bit about the Purple Campaign. I know that Purple Campaign, its mission is to end systemic sexual harassment in the workplace. We've been covering sexual harassment on this program for 20 years. Sometimes I wonder how much progress we've made.
Well, that's what the Purple Campaign is hoping to do, and we are trying to take this moment that obviously has raised a lot of awareness about the issue and has shown that there's a huge cultural shift that's happened, but to make sure that that's turning into long-term change by pushing for change in the workplace and also in Congress and in state legislatures to make sure the top-down policy change will last into the future.
And what would you say is your biggest challenge as you embark upon this?
I think that there is a really ingrained culture of silence that still exists, even though a lot of women have started telling their stories. Within the workplace, retaliation is still extremely common, and there's a huge deterrent to speaking up. And I think that making sure that cultures are changed from the top down by promoting more women into leadership, for example, those are the kinds of changes that are going to be needed to root this problem out in the long term. And they're longer term and more difficult changes to make, I think, in corporate America in particular.
Alexandra Coll Steele, Ally Steele, joining us from Washington, D.C. Thank you so much for joining us, Ally. You have a good evening. Thank you.
Thanks for having me.
All right. Well, one of the things that the Weinstein matter has brought to light is that most of these issues end up in settlement, and that means confidentiality and non-disclosure.
Gretchen Carlson, former Fox News anchor, found out the hard way.
You're at your job, you're sexually harassed, you have an arbitration clause, and no one will ever know that you were sexually harassed.
In her sexual harassment fight with now deceased Fox News president Roger Ailes, Carlson discovered that contractually she had to arbitrate any legal dispute and keep all details of her settlement confidential. That was due in part to an NDA she signed, a non-disclosure agreement. Common in employment disputes, NDAs prohibit survivors of sexual harassment or assault from publicly discussing the settlement or what happened to them. But Carlson, along with people such as Zelda Perkins, who broke her NDA with Harvey Weinstein, are steering the national conversation. Should confidentiality agreements be permitted in these types of cases at all? Now a number of states, from California to New York, are seriously considering limiting confidentiality and classifying non-disclosure agreements as unconscionable or against public policy.
Already on both a state and national level, there's been new legislation that's been introduced that's going to address sexual harassment in the workplace. Companies are certainly paying attention to these laws that are getting proposed.
And in most cases, the woman is forced to leave the company and the perpetrator stays. And no one hears about it.
Some have said that the Weinstein effect means that this is the end of the non-disclosure agreements and confidentiality. That's not going to happen.
I don't think in reality those things are going to become law anytime soon. They are a visceral reaction to the Weinstein situation. And I think that on both the plaintiff, and I'd be interested in Alice's reaction to this, on the plaintiff side and on the defense side, they have a lot of value in many cases.
I'm interested in knowing that too, because I think you said, look, if someone settles a sexual harassment case, there's always going to be confidentiality. Are we ready for a sea change? Is the law ready for that?
The employer's always going to demand that the amount of the settlement be kept confidential. Then there are these other aspects of it. Can you talk about what happened? And are you allowed to say, that guy is a jerk? I mean, let me tell you what he did to me. And that is sometimes covered by confidentiality and sometimes not, but it's always covered by something that says you can't disparage anybody in the company. And that's different from telling a lie. Disparagement is telling the truth. You can't say he's a jerk, even if it's true. And those clauses, the non-disparagement clauses, can be a big problem. If you want to write your novel, you can't sign these agreements.
Alice talked about the non-disparagement clause. We're neutral during the investigation, and if we can work out a settlement either before we've made a finding or if we think one of our laws was violated and we try to work it out at that stage, we keep it confidential. And there can be some value in that because it can
What's
encourage
the value?
people.
And that's what I'm trying to track down. I understand from Anthony's viewpoint and his clients why this is going to be valuable. Why is it valuable for the plaintiff?
I think, the idea for both sides is it easier to resolve it. Sometimes, for example, in our process, the first thing we ask, first we're going to counsel to see if there's a potential issue under our laws. If somebody does want to come forward and file a charge and understand we're going to send a copy to the employer, we ask both sides, do they want to engage in mediation? There can be, and that's confidential on both sides. And there can be a lot of value in that. It can resolve something much easier, resolving something through our mediation in a few months versus an investigation that could go longer or potential litigation. There's a value in having that resolution, and it gives people an opportunity to air the differences and gives the employer an opportunity to find out what's going on and try to correct it. So there can be some value in that.
And is that what you're seeing, Joey, in the workplace for the clients that you serve?
What I'm seeing in the workplace, Christopher, is it's causing employers to take a second look and an intentional glance at their sexual harassment policy. It's requiring people in the workforce to actually pay attention to training, hold others accountable within the workforce. It's creating an avenue for women at work to feel confidence in, okay, this is a large social societal issue here, and I have that sort of power. I have that acknowledgement where if I do run across the issue of sexual harassment, I have a stronger voice than I may have had before, because at this point, the world is watching how employers are responding to sexual harassment.
Unfortunately, in these conversations, employers often get caricatured as though all they're trying to do is cover up a bad situation, and that's really not accurate. Most good employers want to have policies that are effective, do have these policies. But one of the things we found, and I think what is so good about what's happened recently, is that these policies haven't been effective, and there are a number of reasons for it. But one of the main reasons is that people have not been willing to come forward to support individuals when they observe something. And I think that Alice is right, that the Me Too movement has given voice to those people who have otherwise been silenced. And it was that silence, I think, that was really at the heart of the problems with the Weinstein Company.
The downside, though. What's the downside of it?
We are far too quick to convict. That in this era in which news travels so quickly, we sort of have crowdsourcing of mass condemnation. Let's not forget, in all of the noise around these issues, what happened at Duke with the lacrosse team. That sometimes false allegations can be very harmful and cause immense collateral damage.
Right.
So when an accusation is made, it isn't necessarily true, then there needs within these processes to be some element of fairness and due process. And that is getting lost in the discussion.
We also can't assume that the allegations are not true. I mean, as I said, EEOC, we have a different role than HR. We're neutral in the investigation. One of the things EEOC, even before Me Too, we've been trying to change up how we look at harassment because it's been such a persistent number of our charges over the years. And one of the things, in addition to what Anthony now said, making sure policies, and what Joey said, making sure policies are effective and not just words on paper, trying to encourage the different training, empowering people, if they are bystanders, to come forward and to be supportive, and create a culture change where maybe we address things as respect and not just looking at training as legal compliance, but effectuate a change that everybody will be treated with respect in the workplace, that hopefully things never escalate, and that somebody doesn't get away with being a serial harasser, threatening women or men or victimizing them throughout a career.
Well, former Judge Stephanie Klein, who's now with ADR Options, had a brilliant piece in Legal Intelligencer recently, and she says even with the best efforts, human resource departments often fail to inspire complainants' confidence. Complainants fear their allegations will be swept under the rug. Instead, they will be shown the door. They also fear shunning by fellow employees. Joey, is that fair? Is there an inherent conflict of interest?
Up to this point, yes, I do believe that there is inherent conflict of interest because we have far too often on this matter pitted leadership versus the employee in question. We've pitted the powerful versus the powerless. And I think this Me Too conversation is requiring us to really think about that dynamic and really ask ourselves, what does the good of the employer actually mean? Is it saving the reputation of a very powerful executive, or is it instilling the confidence in our employees? I mean, the court of public opinion, as we've discussed earlier, it is almost as damning as an actual settlement. And so the ramifications of not getting this right is really causing people to have a second look at their executive opinion.
Go ahead, Alice.
I couldn't disagree with you more, Joey. The idea that HR is there to help the employee is just, it's not realistic. HR works for the company. They work for the company. Employees think when they go to HR, that it's a refuge, and it's not. HR's job is to listen, do an investigation, control the damage. It's not to make this person whole, to take her side, to understand, to give her the benefit of the doubt. No. And I think that this is a misconception that a lot of employees have, and this is a problem with the Me Too movement, because with Me Too, you go to the press, and the press tells your story. It's good news. You go to HR, that's not at all what happens. And you cannot go to HR confidentially. You can't just go and say, I want you to know something. This guy's a problem. I don't want you to do anything, but I'm putting you on notice. He's a problem. You need to know this. HR can't help you. They can't do anything. They say, if you won't make a statement, there's nothing we can do. They don't want to know about a repeat offender unless you're willing to stick your neck out and be the bellwether.
I deal with HR all the time, and I deal with HR all the time when they are doing these investigations, and I don't really agree with that characterization. I think in many, many cases that they are really trying to do the right job, get to the bottom of the issue and resolve it and do it the right thing.
The
now,
HR is, Anthony, I agree with you, but they're not the final, then the lawyers come in. Sorry.
But not always, and quite often the lawyers don't come in. What I will say is when you're dealing with people at a very senior level, I think HR is very much compromised and very much conflicted, and I urge everybody to read this complaint by the Attorney General, because a raft of complaints went to the head of the Vice President of HR at the Weinstein Company, and she wasn't able to do anything about it because she referred it to the COO, and then she was told that was it. So she was excluded from the process. So I think it's time to really look at these situations, and where it involves senior executives, I think you have to have a completely different procedure. And particularly if you're a public company, there has to be...
So you would say bringing in a third independent party?
Completely. And not the traditional lawyers. You need right. A completely different way of handling these situations.
Because a human resources individual may have the best of intentions, but they don't necessarily have the power.
Exactly.
Absolutely.
Right. Is that fair, Joey?
That is 100% accurate. We do have the best intentions. My colleagues are some of the most empathetic people in the workplace. We want to do the right thing, but at times we are handcuffed based on the executive perspective on the matter. We are not at times going between right and wrong. It's who is more valuable to the organization. And I think we really need to address that fact before we can move forward in a way that is beneficial to all parties.
You know, something, go ahead, Mary.
That's one of the things that EEOC warns about. You know, you can't let anybody, the superstar, get away with things. I mean, it really comes down to leadership and accountability. Going back to Alice's point, though, if people don't let the company know, the company can't take any action. And if the person wants to go forward on her own behalf with a charge to EEOC or go into litigation after that, if she can't show that she put the company, that the company knew or should have known and didn't take action to stop it, that can be an obstacle then to holding them liable. I mean, I understand the concerns about retaliation, and EEOC obviously takes that as seriously as we do the concerns about the initial harassment allegation. But if the person doesn't put HR and the company on notice in some way, then she might not be able to prevail later if that's what she wants to go, if she wants to come forward and file a charge.
And I think we're driving all the way to the far end of the spectrum here when we have a conversation about sexual harassment. There are various levels of sexual harassment at work. I've had an experience where I spoke with a senior member of one of my clients, informed them that the way that they were speaking to several young ladies at the organization rubbed them the wrong way, created the environment of sexual harassment. And that intervention, it helped build trust with that executive, and it also built trust with the employee. If HR can intercept at those earlier levels of the spectrum, I think we can all be in a better place.
That's one thing we're trying to encourage with the training. Again, going back to that leading for respect or respect in the workplace, to address things earlier so things don't have to escalate. Don't let it be the gateway drug, this lack of respect in the workplace. Don't let it be there so that it can escalate to things like possible liability for harassment.
I have one more issue. I'm going to parry off of this, and I'm going to pose it to Alice Ballard. Actually, I'm not going to pose it to Alice. I'm going to let Alice Ballard pose it to Alice.
You can't complain about sexual harassment without being retaliated against or without planning to be retaliated against. When somebody comes
So that was 6 years ago, same as it ever was?
It is the same, and the problem, part of it is systematic, because the system will not allow you to make an anonymous complaint. The system will not allow you to inform the company of a problem when you're saying, I just want you to know. I don't want to make a formal complaint. I don't want you to do anything for me. I don't want an investigation. I just want to go on with my life. But you need to know this, because as Mary said, the company needs to know about repeat offenders. They're the most dangerous people. But the way the system is set up, the company cannot receive an anonymous complaint and not do anything. And it's very, very dangerous not to make an anonymous complaint.
Anthony, I'm going to let you sum up and wrap this up in a nice little tidy package for us tonight.
Well, I do think that we're dealing with a wide spectrum of behavior, and Matt Damon got into a lot of trouble for saying this, but it's true. So when we talk about sexual harassment, that covers a lot of different kinds of behavior, some of which is relatively minor and some which is egregious. What I will say, and picking up on what Alice just said, is I think it's incumbent upon every employer to rethink what they're doing. And I would take every policy, I would tear it up and start again. And one of the things I think you need to do, particularly for public companies, is you have to have an anonymous complaint procedure. And the board has to have the ability to find out about things without a specific complaint being made by an individual who's then subject to an investigation. And there needs to be independence in the investigation of these things. And I think that we are finally realizing that covering up activities that can in fact be criminal in nature has much more serious ramification ultimately for the people that are running companies than not acting.
We could obviously spend a lot more time on this, and maybe in the future we will. Anthony Haller joining us tonight with the corporate defense firm of Blank Rome. Mary Tiernan with the EEOC. Education and training is her coin of the realm. Alice Ballard is a plaintiff's attorney, and she dukes it out with the likes of the Anthony Hallers of the world. And Joey Price with Jumpstart HR, with offices in D.C. and in New York City. Joey, thanks for joining us. For all of us here, thanks a lot for joining us. Until next week, case closed.
This week's American Law Journal has been made possible in part by Find-Lawyer.com, the nation's video legal directory. Meet your lawyer before you meet your lawyer. King Spry, serving its clients in family law, business, personal injury, and school law for decades. Schwartz-Culleton PC. If you've been injured, get the justice and compensation you deserve. Beatty, Sloan, and DeGenova, providing consumer protection in personal injury, workers' comp, and dangerous product matters for over 30 years. And The Legal Intelligencer, an American lawyer media publication and the oldest law journal in the United States.